Nobody is giving the answer to my question.
Good evening.
Read what I posted on the screen. Anyone?
Yes, no. The criminal rules of
Read from the beginning. Read from the
2019
beginning.
with effect from, that is not 1/1/2020. Hosts are K. Sharad Babu, M. Srividya, and Professor Hussain.
Yes. Again, once again, I will say welcome to the today class of the JCJ Junior Civil Judge 2022, which is going to be held on 13th August of this month. It is a screening test. Just now, the Kolikonda Sharad Babu has read it because other people did not read it, and they said that they could not hear my voice properly. But anyway, that without wasting the time, Motamari, are you ready?
Yes, sir. Yes.
Okay, now I will give the chance. Later, I will give the chance to the. Yes, it is the civil road criminal practice. I'm searching where I kept your file. I opened the file. Your file I opened. Yeah, it is here. Yes, now JCJ 2022 State of Telangana Civil Rules of Practice. Oh, this is mine. Not, I want to show yours. This is also mine. No, it should be here. Two are here. Just a minute, it is hiding somewhere. Please mute. Yes, Mutamari, ready. Mamta Kaur, mute.
Yes, sir.
Mamta Kaur, mute. Okay, read.
First question: can party appear by agent other than advocate before the court and sign and verify the proceedings? Option A: the party cannot appear through agent. Option B: the party can appear only through advocate, but not his agent. Option C: the party can appear through agent by filing advocate to seek permission to the court. Option D: the personal appearance of the party is not permitted.
Is only permitted.
Is only permitted.
Option C.
Yes, option C is the correct answer. The party can appear through agent by filing advocate to seek permission of the court, according to Rule 32 and 33 of Civil Rules of Practice. Option C is the correct answer. Second question: can a party or his counsel in respect inspect the documents filed in court? Option A: the party or his counsel, with the permission of the court, can inspect the document filed into court. Option B: the party or his counsel can inspect the document filed in the court. Option C: the party or counsel cannot inspect the document except the copy served to him. Option D: the party or his counsel, with the permission of the opposite party, can inspect the documents filed into the court.
Option D.
Option A is the correct answer. The party or his counsel, with permission of the court, can inspect the documents filed into the court, according to Rule 107 of Civil Rules of Practice. Third question: the petitioner filed a petition under Section 5 of Limitation Act to condemn the delay and also to set aside the ex parte decree. No separate application filed under Order 9, Rule 13 of CPC, Rule 55 of Civil Rules of Practice mandates that separate application for each distinct shall have to be filed. An exception where one relief claimed in that application is consequential to other. Can the application is maintainable? Option A: the application continuation of delay under Section 5 of Limitation Act is not considered. The application filed under 9 cannot be taken up as they squarely fell into the category of consequential relief exempted from the Rule 55 of Civil Rules of Practice, therefore maintainable. Option B: the petition is not maintainable as two prayers are barred under Rule 55 of Civil Rules of Practice. Option C: the court has to return the application as a petition has to be filed two separate petitions, as a petitioner has to file two separate petitions under Rule 55 of Civil Rules of Practice. Option D: none of the above. Guess the answer.
Option C. Guessed answer.
Option C. No, it's not correct.
Option A.
Yes, option A is the correct answer. The application condemnation of delay under Section 5 of Limitation Act is not considered. The application filed under Order 9 cannot be taken up as a sequentially fell into the category of consequential relief exempted from the Rule 55 of Civil Rules of Practice, therefore which is maintainable. Fourth question. A petition where by any proceedings other than a suit or appeal or any proceedings in execution of a decree or order is instituted in a option A complaint, option B virginal petition, option C application, option D execution petition. Should they answer?
Say loudly.
Option D.
Option D is the wrong answer, ma'am. Second chance.
Second option, shoot.
Option C.
Option B. Original petition.
Yes. Option B is the correct answer, original petition. According to Rule 2, Clause K. Fifth question. An application to the court in any suit, appeal or proceedings already instituted in such court, other than any proceedings for execution of a decree or order. Option A, interlocutory application. Option B, execution application. Option C, virginal application. Option D, insolvency petition.
Option A, interlocutory application.
Yes, option A is the correct answer, interlocutory
Option
application.
A.
Yes, option A is the correct answer. Sixth question. Can the copies of the suit document shall be served upon by the defendant along with the plaint after listed? Option A. Even plaint shall be accompanied with as many copies of the plaint. Option B. Not required to serve the defendant with plaint. Option C. If served to the defendant after filing petition. Option D. Served at any point of time.
Option A, every plaint shall be
Option B.
accompanied with
Option A.
many
Not
copies.
required.
Is the correct answer.
Option A is the correct answer. Every plaint shall be accompanied with as many copies of plaint. According to Rule 20, Clause 4. Option A is the correct answer. Seventh question. Petitioner failed to furnish particulars of amendment sought in spite of direction by court on such prayer. The court dismissed the petition as the amendments sought are not incorporated in the petition whether order is justified. Option A, order is justified as any application is contravention of Rule 54 of Civil Rules of Practice shall be returned. Option B, the order is not justified as as under Rule 54 of Civil Rules of Practice. Option C, the interlocutory application shall not be required to follow the provisions of Rule 54 of Civil Rules of Practice. Option D, not the above are correct. Should the answer?
Option C.
Option C, no ma'am. Option C is the wrong answer.
B, madam.
Guess.
So option A
Madam?
might be the right answer.
Yes, option A is the correct answer. The order is justified as any application is contravention of Rule 54 of Civil Rules of Practice shall be returned. Eighth question. Can the court issue summons to public officer for production of documents in whose custody requires, instead of the original copy, certified in manner prescribed by Section 76 of Evidence Act? Option A, the court cannot issue summons for original if the certified is available. Option B, it is a liberty of public officer either to produce the original or its copy. Option C, the court can summon for production of original as it requires. Option D, the court can summon for the production of copy only.
C, madam.
Yes, option C is the correct answer. The court can summons for production of originals as it requires. Ninth question. In which circumstances the court can adjourn the proceedings sine die? Option A, no suit appeal shall be adjourned sine die, providing in a suit for partition in which primarily a preliminary decree has been passed, the court may adjourn the proceedings sine die with liberty to parties to apply for passing final decree. Option B, the court has no right adjourn the proceedings sine die anytime. Option C, it is a discretion of the court to adjourn the proceedings sine die at all the times. In any suit, appeal or petition, the court can adjourn sine die.
Option D.
No. What is the meaning of this sine die?
Participants, sine die or sine die?
Idea, I think, sir. I'm not sure about that. It's a
Without,
Latin term. Yes, it's
without
a Latin term.
mentioning any time, prolonged.
Yes,
Till
sir.
the further orders.
Any meeting should be ended with the next date.
Sine die means till the further orders.
In
Yes.
Parliament also, it is often used.
Yeah,
Parliament is adjourned sine die.
Sine die.
you're right. What is the right answer?
Okay.
Yes, option A is the correct answer, ma'am. No suit appeal shall be adjoined sine die, provided in suit for partition in which preliminary decree has been passed. The court may adjoin the proceeding sine die. Is
Sine
it
die.
sine die, sir? Sine die. Sine die. Okay. With liberty to parties to apply for passing final decree. Option A is the correct answer. Next question.
10th.
Yes. A test identification conduct after 5 months. The particulars of the accused was not mentioned in the FRA. The PW2 who is injured witness saw the accused 1 year after the offense. The PW3 who lost a ring and who was beaten could not identify the accused before the court. Can the magistrate conduct the test identification period as under the rules provided? Option A, the magistrate who conduct the test identification period violates the rules. Therefore, recovery of property not provided. Option B, the
So when is
magistrate
not
conducted the
proved?
test identification.
Is it property not proved or
Yes,
provided?
property not
A.
proved, sir.
Huh?
Yes, property not proved.
Yes. Next. B.
The magistrate conducted the test identification as under rules. Option C, the test identification is basic for proving the property. Option D, test identification is a basic to identify the accused.
Option D.
Option D.
Option D.
Option D.
Identification is basic to identify the accused.
No, ma'am.
Option A.
Option B.
Option A is the correct answer. Magistrate who conduct the test identification period violates the rule. It's under Rule 34 of Criminal Rules of Practice. Therefore, recovery of property is not proved. Next question. The court has to marking the documents admitted in evidence shall be marked under Rule of Criminal Rules of Practices. Option A, Rule 54. Rule 56, option B, Rule 61, option C, Rule 58, option D, Rule 64.
Option C, Rule 58.
Yes. Option C is the correct answer, Rule 58. It was little jumbled. Next question. Option C is the correct answer, sir, Rule 58.
Yeah.
12th question. Identification of property to be taken place in criminal court following under Rule 35 of Criminal Rules of Practice. First one, identification period of property shall be held in court of the magistrate where the properties are lodged. Second one, each item of property shall be put up separately for the period. It shall be mixed up with 4 or 5 similar objects. Third one, before calling upon the witnesses to identify the property, he shall be asked to state the identification marks of the property. Witnesses shall be called in one after other, and on leaving shall not be allowed to communicate with the witnesses not yet called in. Fourth one, identification shall be taken place in open place. Which of the following correct? Option A 1 and 2, option B 1 and 3, option C
2
1
and 3.
and 4, option
B. 2 and
yes, 2
3.
and 3. B 2 and 3, option C 1 and 4, option D 1, 2 and 3.
Option B, 2 and 3.
Option D. Option D. 1, 2, and 3.
Yes, option D is the correct answer. 1, 2, and 3 are correct regarding identification period. Yes, sir.
Yes, thank you very much, Mutamari
Thank you, sir.
Sri Vidya, for making this nice presentation as well as framing the questions also in the both the civil and criminal rules of practice. Now, Kolikanda, are you ready to read?
Yes, sir, I am ready to read, but I am not ready to answer.
No, I will answer. I will answer it. Yeah. Civil and procedure,
Okay.
MSV, it is here. Then where is mine? Yes, CRPC, no. Yeah, it is here. Okay, JCJ to 2022, State of Telangana, Civil Rules of Practice and Criminal Rules of Practice, multiple choice question. Now the first question, read, Kolikonda.
The first question is the Andhra Pradesh Civil Rules of Practice and Circular Orders 1990. How many form number of Appendix 3 capital A? Option A 74, option B 75, option C 76, option D 77.
Option A 74.
Run.
Option B 75.
WRONG.
Sir, that's the civil rules of practice or criminal rules of practice?
What is
Yes,
made
it
there?
is very much there, civil
Civil rules of
and-
practice.
Option D, sir, 37.
Option D.
Option C wrong. Option D is a RIGHT. Right.
Right.
Second question.
Sir, these are applicable to Telangana also.
Option C is the correct
Same,
answer.
because at the time they did not change it. Now the Andhra Pradesh is removed and Telangana is put it over there.
Okay, sir. Second question. Placed by the trial court or Rule 22 of the Andhra Pradesh Civil Rules of Practice and Circular Orders 1980. For brevity, the Civil Rules of Practice -22 of the Civil Rules of Practice that all original documents relied upon must invariably produced along with the plaint. In fact, no such requirement could have been prescribed in the said rule. Dash was observed in the case of Dash. Option A, Mohammed Usman Ali versus Second Junior Civil Judge, City Civil Court, Hyderabad. B, Pujari Narsaya versus Modem Sudhakar and others. C, Dantala Praveen versus Bhairaboyina Veeramma. Option D, Kavita Balaji and another state of Telangana and others.
No minus marks.
Option C. Option C.
WRONG.
A.
Option A.
Wrong.
Option B, Pujari Narsaya.
RIGHT.
Model
Right.
Sudhakar.
Pujari Narsaya versus Modam Sudhakar and others is the right answer for the second question.
Option B is the right answer. Pujari Narsaya versus Modem Sudhakar and others. Option B is the right answer. Third question. In this context, it is to be seen that the AP Civil Rules of Practice, which were formulated by this court with the approval of Governor of the Rules 59, 54, and 48 of Civil Rules of Practice prescribed by the High Court, with the previous approval of the Governor of Dash only by the person who made the application. But on the contrary, Rule 54 of the Civil Rules of Practice envisages that an application can be signed either by the Dash, decided in the case of option A, Sri Shanmugar Mills Limited versus CIT. Option B, CIT versus Margadarshi Chit Funds Private Limited. Option C, DK Enterprise versus ITO. Option D, G. Krishnamurti versus Hemata Chit Funds Private Limited, Warangal and others.
Option B, sir. CIT versus.
Wrong. Second option.
Option D, sir.
RIGHT, right. G. Krishnamurthy versus Hemata Chit Funds Private Limited, Varangal and others. That is the right answer for the third question. Next.
Now the fourth question is, further Rule 29 of Chapter 2 of Andhra Pradesh Civil Rules of Practice and Circular Orders 1990 provides as under review petition or that one Srimati Sheila Devi, wife of late Sri Bahadur Singh Parmar, filed civil suit under Section 926 and Order 7, Rules 1-2 of the Code of Civil Procedure and Sections 38 and 3, apt court rules 3 of Chapter 2, Part 1 of Himachal Pradesh High Court, scrutiny, maintenance of judicial records, administrative and executive business rules 1997, which reads as under A. High Court of Himachal Pradesh versus Sheila Devi. Option B. Kesar Singh versus State of Punjab. Option C. Punjab State Electricity Board versus Narata Singh and another. Option D. Roy Singh and another versus Kurukshetra University.
Option A.
It is clearly mentioned in the question itself, Himachal Pradesh High Court. At least by reading that one, we can make it out. RIGHT, right? Option A.
Now the fifth question is, read with Rule 129 of Andhra Pradesh Civil Rules of Practice and Circular Orders 1980, and even if proper application is not filed, the trial court on its own motion summoned the public M. Gangarao when the civil revision petition is filed under Article 227 of the Constitution of India against the order dated 11/6/2019 passed in IA number 166 of 2018 in interim applications, or is it number IA number 1137 of 2017 in original suit number 189 of 2012 by the additional senior civil judge Kadapa, whereby the application filed under order 13 rule 10 of the Code of Civil Procedure seeking to summon the schedule. Option A, G. Umadevi versus M. Krishnamurthy Reddy. Option B, Krishnaveni versus Ramadevi. Option C, Pakala Reddy died versus Kambala Guruvi Reddy. Option D, the manager versus G. Elumalai.
Shoot.
Pass on.
No minus marks. Try.
Option B, Krishnaveni versus Ramadevi.
Wrong. Second option.
Option C. Option C.
RIGHT, right. Option C. Pakala Polireddy, within parenthesis, died versus Bala Guruvi Reddy. That is the right answer. Sixth question.
Under Rule 32 of the Civil Rules of Practice, seeking permission of the court to represent the petitioner in the execution petition, the permission sought for was accorded by allowing EA number 2 of 2014 on 2/11/2015 by the court. It is this order dated 2/11/2015 which is challenged in this revision. Option A, Dantala Praveen versus Bhairaboyina Veeramma. Option B, Sri Sudarshan Rao and another petitioner versus the Citizen Cooperative Society Limited. Option C, Valluru Chinnalakshmi versus Majid Dharmarao. Option D, Shabir Ahmad versus Shamshad Begum.
Option
Yes, sir.
B. Option B.
Option B is the right answer. Sri S. Sudarshan Rao and another petitioner versus the Citizen Cooperative Society Limited is the right answer for that sixth question. Yes, seventh question, read. Okay, repeat.
Seventh question.
Vadukondla, repeat the seventh question. It is not recorded.
Yes, sir. Seventh question. ROC number 13 oblique SO oblique 88. Whereas it is expedient to amend, consolidate, and bring up to date the dash in accordance with the new Code of Criminal Procedure 1973 and incorporate therein the orders, notifications, and administrative instructions issued from time to time by the government and the apex court of the state. Option A, Civil Rules of Practice and Orders 1966. Option B, Civil Rules of Practice and Orders 1965. Option C, Criminal Rules of Practice and Orders 1965. Option D, Criminal Rules of Practice and Orders 1966.
Option D.
Say loudly, Lavanya.
Option D.
Right answer. Option D
Criminal
is the
Rules
right
of
answer.
Practice and Orders 1966.
Yes.
Option D is the right answer. Now, eighth question. ROC number 13 oblique SO oblique 88. Whereas it is expedient to amend, consolidate, and bring up to date the Criminal Rules of Practice and Orders 1966 in accordance with the new Code of Criminal Procedure 1973 and incorporate therein the orders, notifications, and administrative instructions issued from time to time by the government and the A. Option A, Supreme Court. Option B, High Court. Option C, District and Session Court. Option D, First Class Magistrate Court.
Option B. High Court.
Right. RIGST, right. High Court. It's the apex court of the state. Ninth question.
Now, sir, every state has this
Yeah.
power. Every High Court of the state.
Yes.
Ninth question. ROC number 13 oblique SO oblique 88. Whereas it is expedient to amend, consolidate, and bring up to date the Criminal Rules of Practice and Orders 1966 in accordance with the new Code of Criminal Procedure 1973 and incorporate therein the orders, notifications, and administrative instructions issued from time to time by the government and the High Court. Now, therefore, in exercise of the powers conferred by dash of the Constitution of India, option A, Article 32, option D, B, Article 226, option C, Article 227, option D, Article 228.
Option C,
Option B.
Article
Article
227.
226.
It is right.
Option C.
Option C is the review petition. Article 227 is the right answer for the ninth question. 10th question.
Yes. Now, 10th question is, what is short title of Criminal Rule of Practice rules may be called the dash? A, Criminal Rules of Practice and Circular Orders 1990. Option B, Criminal Rules of Practice and Circular Orders 1991. Option C, Civil Rules of Practice and Circular Orders 1990. Option D, Civil Rules of Practice and Circular Orders 1991.
Option A,
B.
Criminal Rules of
Option
Practice
B.
and Circular Orders
Yeah.
1990.
Option A
Just
seems
use
to
the
be
logic,
right
you
answer.
could know the answer. That is, option A is the right answer. Criminal Rules of Practice and Circular Order 1990. Okay, next 11th question.
Yes. Which section says about the hour of sitting of course in general from stipulated hours dash Criminal Rules of Practice and Circular Orders 1990? Option A, Section 3. Option B, Section 4. Option C, Section 5. Option D, Section 6.
Section 3. A.
Right. Section 3 is the right answer. Next.
Section 3, yes, sir.
Yeah.
That means option A is the right answer. The
Yes.
12th question. What are the working hours of session court or general other courts as per section 3 of Criminal Practice and Circular Orders 1990? Option A from 10 a.m. to 4:30 p.m. Option B from 10 a.m. to 5 p.m. Option C from 10:30 a.m. to 5 p.m. Option D from 10:30 a.m. to 5:30 p.m.
Option D.
Option C, 10:30 to 5 p.m.
The right answer is option C.
Option D.
That is 10:30 a.m. to 5:35 p.m. Next.
13th question. What is the lunch
Option
break of the court in general dash and which section says? Option A 1:30 p.m. to 2:32 p.m. and section 3. Option B 1:45 p.m. to 2:15 p.m. and section 4. Option C 2 p.m. to 2:30 p.m. and section 3. Option D 2:15 p.m. to 2:45 p.m. and section 4.
Option C, 2 to
Option
2:30
C.
of
2
section
to
3.
2:30, section 3.
Yes,
RIGHT
option C is
right.
the right.
Option C. That is
Practicing lawyers easily know it.
Yeah, yeah, yeah.
2 p.m. to 2:30 p.m. and section 3.
What is the answer for 12th question? C or D?
C is the right answer.
C is the correct answer.
Okay, sir.
14th question. Which one is false statement? Option A. Judicial work insofar as it relates to inquiries and trials shall be done in the courthouses. Option B. Magistrates appointed to mobile courts may hold their sittings at any place within their territorial jurisdiction. Option C. Cases relating to juvenile offenders and women may be tried in chamber. Option D. Urgent bail application presented out of court hours may be disposed of at the residence of the magistrate, but no order shall be passed in the case of non-bailable offences without notice to the prosecution.
Option C.
Option C,
Option C.
cases relating to juvenile offenders and women may be tried in chamber.
What would be the right answer? I mean, right word.
In camera,
In camera.
not in chamber.
In
Not in
camera,
chamber.
in camera.
In camera.
Feedback I have given. Cases relating to juvenile offenders and women may be tried in camera. That is the right answer. Okay, supplementary questions. Rape cases, either it is a single rape or gang rape cases, could you reveal the victim name in the case law?
No, not
No,
at
sir.
all.
No, sir.
No.
No, sir.
Example?
Disha case.
Yes.
Example,
Nirbhaya
that
case.
is Delhi case, sir.
Yes, gang rape case.
Hmm.
Nirbhaya.
Yes, Nirbhaya case.
Can you tell me what are the parties in the Nirbhaya case?
Some minors are there.
I think her name is Jyoti Singh.
Yeah. Mhm. Okay, now these are the things we framed it, but we have the even the act itself. I made it here so that, and these are the cases. Still, I did not make it you that I will read the cases. Composite High Court of Andhra Pradesh has framed the Andhra Pradesh Civil Rules of Practice and Circular Orders 1980, exercising the powers under Article 32 of the Civil Rules of Practice, seeking permission of the court to represent the petitioners in the execution petition. The permission sought was a Code of Civil Procedure which dealt with suits by the against the corporation. Rule 1 thereof would be set out in the suit by against the corporation, and pleading may be signed and it is dealt in the case of.
You have already given. Mohammed Naeem versus
No,
Sailasai.
that is not the right answer. Above one is the right answer.
Okay, yes, Sudarshan Rao and another petitioner versus the Citizen Cooperative Society.
Society Limited. So that is the right answer for that one, because this I have not framed the multiple choice, but I want to read it so that you could have an idea. Suppose the orders are given, which case law it says about it, you could have an idea. Yes, now next is Order 4 Rule 1 CPC, but affidavit is not a part of pleading and it is not defined anywhere in the Code of Civil Procedure. However, according to Section 3, Subsection 3 of the oath or affirmation that is required to be administered to the party seeking to make his own affidavit, Rule 40 of the Civil Rules of Practice framed by the General Clause Act, interpretation in Civil Rules of Practice and circular orders is to be taken into consideration in the dash. The case of Mohammed Naeem versus Saleh Saeed, it is decided in that manner. The next, pleadings defined under the Order 4, Rule 1 CPC, but affidavit is not a part of the pleading. No, that is the, yeah. It's 9th. Okay, let me say up. Oh, that is the Muhammad Naeem versus Saleh Saeed, only the answer. Yeah, this is also repeated again. So now the next is, last one is, and it is not defined anywhere in the Code of Civil Procedure according to Section 3, Subsection 3 of the General Clause Act 1897. The term affidavit means affidavit shall include affirmation. The rules of practice framed by the Andhra Pradesh High Court provides that the officers before whom an affidavit is taken shall state the date on which, the place where the same is taken, and the definition of the General Clause Act and interpretation of the Civil Rules of Practice and circular orders is dash. It is defined in the, again the same, Muhammad Naeem versus Sri Saleh Saeed case law, it is again the decided. So 3 are the cases same. Because now you tell me, supplementary question, affidavit is defined in the civil rule of practice or not? Yes?
Not defined.
Yes, sir.
From where we have to take it? Supplementary question.
General Clause Act.
Which section?
3, Section 3, Subclause 3
Section
of
3, subsection 3.
Section 3, subsection 3 of the General Clause Act 1897, we have to take it, the definition of it. Like we say, either the movable property is not defined or immovable property is not defined in the Transfer of Property Act.
Yes, sir.
There, again we take from the General Clause Act.
Yes.
Is it the movable property or is it the immobile property? I think it's the immobile property.
Yes, sir. Immovable property except timber and standing crops. And
Even immobile property also we can take from the Registration Stamps Act or Registration Act.
Registration Act.
From there we can also take the definitions. So this is what I would like to share. Another point also. Yeah, now the time still, would you have it some time in addition to the extra time, because 1956 means still would you have 4 minutes in our hand. And next class that what we are going to deal is
NI Act and DVC Act.
On 8th.
But what about tomorrow? Holiday?
As of our schedule, it's holiday, sir.
Take tomorrow, sir.
See, tomorrow I am traveling. Perhaps I may be in the car. So I don't think that I could hold the tomorrow session. But we will do it definitely on Sunday. Which we miss tomorrow.
Okay.
We will deal it on Sunday. Okay?
Okay, sir.
And then what we are going to deal on Sunday?
NI Act and DUC.
No, on 8th it
No,
is
sir.
and
Previous paper.
on 7th.
You may deal with one question paper.
So again, the old question paper will deal on Sunday.
Okay, sir.
Sir, all
Or
question
in,
papers
or
already
in
all
general
over
also, you
NI
can
200,
go
DVC
on
100.
explaining.
Changanya, mixed together. Some
Yes,
some
that
some
is-
from there, some from
yes,
there, some from there, some from there will coordinate,
yes, yes.
which will
Sir,
feel more
people are giving
important.
some
Important,
opinions.
important from all syllabus.
Yeah, all fields. We feel that students are supposed to know it,
That's
and we
better.
will pick it out in that way that we will deal it on Sunday.
Because
Okay.
Okay, sir.
already the question papers are in the domain. That's why they
No,
can
question
practice.
papers are on the demand. Some are ticked, some are not ticked.
Yes.
Yes,
So
sir.
11th,
Yes,
okay,
sir.
we can take it up, but on the other days which we don't have any schedule, it is better to take up the mixed type of questions which
No,
are
let
very
me
important.
ask the participants. What is your view? Can you deal the old question
All
paper?
the questions,
All
sir.
important. No,
Or we
not all
can
the
pick
question
out
papers.
important in all the
Only
places.
important question, whatever important, we'll discuss.
Yes,
All
whatever we
important
feel
questions from all
important, either
syllabus.
in the contract or evidence or the IPC, and we'll pick it out from the various points, and we'll see that that will be known to our students. Is it okay?
Yes, yes.
Okay,
Sir,
sir.
one more request, sir. If
Yes.
participants are having any material or important questions like that, they can share with us.
If you say like that, no, they will
Okay.
all the doubts they will make you dump,
Okay, sir.
which
So
we have to suffer
one
again.
thing,
Yes, it became
also
very
I
hard
want
regarding
to
civil and criminal
suggest,
rules of practice, sir. Finding out some questions.
It
sir,
is your choice.
Okay.
sir, one thing also I want to suggest, sir.
Yes.
Taking up question paper, previous question paper, so such type of questions may be asked, and from this syllabus, such type of question may be asked. You
You
can
frame
also
in that angle.
Yes, yes.
You frame in that angle. I frame in my angle, and Mutamari Srividya will fight in her angle. Okay? Say yes.
I may not be having.
Okay,
I may
sir.
not be having such chance, sir, because tomorrow I'm leaving for India.
Okay. So you will be in the plane.
Yes, yes.
Okay, we'll deal that tomorrow anyway. That there is no class tomorrow. I already told you. Class only on the
Yes, yes.
Saturday. I mean Sunday.
Even on 7th also, I will not be available.
Okay, doesn't matter. We will both deal the show.
Yes.
Agreed?
From 9th, I may join, sir. most probably.
Okay, agreed. Right?
Okay, sir.
Yes, with this that I would like to wind up. Thank you very much. Asante Sana, thank you. And now I will close my,
Thank you, sir.
yes, I will close
Thank
the
you, sir.
meeting. Have a good day. Goodbye, Jai Hind.
Thank you, sir.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
We live in a world full